Good evening. This is the special meeting of the Board of Selectmen for July 24th. Would everybody rise to the pledge? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. So tonight's agenda is Valley Green Grove, 44 Old Worcester Road, completion of documents to effectuate vote on May 15th, 2018. Later reaffirmed June 19th, 2018, including host agreement and non-opposition letter. 3, other business unknown at the time of posting. And 4, the board will adjourn to executive session for to conduct strategy session in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel contract. And from there, we'll be exiting executive session just for the purpose of adjourning. So with that, Attorney Silverstein is here. He is going to tell us what is going on with the paperwork.
All right, I'll try to walk you through it.
Mm-hmm.
As I understand it, the board a week or so ago on the 17th executed the development agreement with Valley Green Grove.
Mm-hmm.
The development agreement, you'll recall, has a schedule on the last page of sample documents that are exhibits to the development agreement that will be executed in the future, but rather than say in the future the parties will execute some form of host community agreement, for example, it actually gives the form host community agreement and attaches it so that there's no doubt about what that host community agreement will look like. And so that's just one example. So I'll just walk you through one by one. The board, I think, has seen these documents. Schedule 2GA is this very short form letter of opposition. The board previously reviewed and approved that. It is the form that is used by the state, so there's really no magic to it. It's very short and to the point. For Schedule 2GB is a standard form host community agreement. This is the host community agreement form that will apply for non-retail license applications on the site. So the cultivation license, obviously, as well as any ancillary licenses for manufacturing and processing. The board has not previously seen this document because it's sort of based off of the retail host community agreement, which I wanted to make sure the board was comfortable with before preparing another agreement based off of it in case there were any changes. The primary thing that's different about the non-retail host community agreement is that there are a couple things. Number one, it doesn't attach a remuneration agreement because that applies to the retail, because the various the payments that the town will be receiving for non-retail use is under the development agreement. So there was no need for another remuneration agreement. And something that the board may want to note is that this standard form host community agreement makes clear that any processing use, manufacturing use has to be ancillary to accessory and incidental. If you look at the top of page 3, paragraph 3, mm-hmm. It says that the licensee acknowledges and agrees that the marijuana manufacturing and processing use authorized pursuant to this HCA shall only be accessory and incidental to the primary use of the property for marijuana cultivation and shall be limited to cannabis grown on the property. So they can't import cannabis grown from off-site and just use this as a manufacturing operation. It's really ancillary and incidental to the cultivation, just as the orchard might turn its apples into wine or cider donuts or whatever else. They're going to turn their cannabis into cookies or oils or whatever other things they're gonna use to process what they grow on site. So that is the standard form host community agreement. The retail host community agreement, the board previously saw and approved. The only change to this document, well, two, in the second paragraph on the first page, we just inserted the property address. And then on page 2, paragraph 1A, the VGG asked to insert the word state in the 1, 2, 3, 4th line before, so it says will not violate any judgment, order, or state law, bylaw, or regulation. The reason being, of course, at the federal level, technically cannabis is still not lawful, so they wanted to be clear that this was applying state law as well as any local bylaws or regulations. And then the so that's the development agreement package. The board previously executed the development agreement. This is basically just filling out the exhibits. Nothing that the board really needs to do there, except maybe at the end of this meeting, just take a formal vote to, approve the full package as submitted. The last document before you is an escrow agreement. So you'll recall that under the development agreement, there's an upfront payment of $500,000 that the town receives after issuance of a building permit, but that has to be paid into escrow within 30 days of signing the development agreement. And so in order for...
John, I don't think we have that one.
We're not seeing the escrow agreement. We may not have a copy of that.
should we make some
I can tell.
copies?
And just a quick question through the chair. Are we supposed to also have copies for people in the audience for the open meeting law at this point? Just so they know what we're kind of going through?
Could certainly make extra copies. The open meeting law doesn't technically require that, but I think it's a good idea. There are two people here, so I think it's only fair to make a couple
could ask
extra
So they know
copies.
what we're talking about.
No,
That was
that's
my
fair.
interpretation
Are you
of it.
talking about
Yeah.
what we have, these here, the host agreement?
Yeah.
Yeah.
No, it's just so people understand what we're talking about, that's
Yeah.
all.
Yeah, no, that's fair.
We'll ask, let me ask Mary to make one. Mary's making copies for you guys.
Okay.
Thank
Yep.
you.
Thank you.
You're welcome. Pretty standard
Yeah.
agreement.
Did you want me to wait until the other copies,
Um,
or talk about this document?
let's talk about this
Sure.
document, they have these.
Okay.
Okay.
So the development agreement calls for this infrastructure payment to be paid into escrow within 30 days of execution, and then released to the town upon the building permit being issued. So that's essentially what this escrow agreement calls for. You know, it's similar in a real estate context. If you're buying a house, either the buyer's agent or the seller's agent will keep the deposit pending closing. So that's essentially what this is. It's pretty standard, and it provides for the $500,000 to be released to the town upon issuance of the building permit and expiration of the appeal period. And you know, it provides that the developer is responsible for paying any fees or indemnifying the escrow agent, who is the developer's counsel anyway. So the town has no exposure or liability under this agreement.
Okay, excellent. So,
So this would be a document that the board would want to vote on and sign, so that we can get that money paid in within, you know, by my count, by August 17 would be the 30 days.
so, okay. So, does anybody have, first of all, do we have a motion?
Mr. Chair,
Mr. Safarov,
move that we accept the escrow agreement.
okay, is there a second?
Second.
Okay, now let's open for discussion. Is there any discussion? Any questions? Okay. Hearing none, seeing none. We have a motion, we have a second. All in favor of approving the escrow agreement?
Aye.
Aye.
Aye. Okay. Okay. One nay, 3 ayes. Thank you. Okay. And what was the next thing you need us to do, Jonathan?
Well, so if you want to go ahead and sign either now or after the meeting, that's fine. You can feel free to use my copy or one of yours.
Okay.
And then the only other thing would be, I don't think it's necessarily required, but if you, now that you have the full development agreement package with all the exhibits in front of you, if you want to just sort of take a confirmatory vote that all of the exhibits are acceptable and consistent with your execution of the development agreement, I think that would be
Okay.
in order as well.
Do we have a motion for the development agreement?
Would I be making a motion to accept the development agreement as written?
Correct.
And exhibits.
And
the
exhibits.
Okay.
Then, so moved.
Do we have a second?
Second.
Okay. We have a motion and a second. Do we have any discussion?
Yeah, I didn't see anything out of place looking at the red line.
Same here, when I compared
Yeah.
it. Did you see anything?
No, I've pretty much gone over it with a fine tooth comb.
And obviously where it says between name and whatever will be inserted later on.
Right.
Exactly.
right.
Okay.
That's the only reason really that the documents aren't ready to be signed now. I suspect what will happen, just so the board knows, is that between now and August 17, the developer will figure out what entity names it's going to use, formulate those entities if they're not already formed, plug in that information, and then have the documents ready to actually execute prior to August 17, when they're gonna be paying $500,000 into escrow and probably will wanna get started with the application process to the CCC.
Okay.
And obviously, if anything changes from their end, that's like completely out of whack, we have the ability to say, hey,
Oh, absolutely.
Let's
Yeah, I
take-
mean,
take it
they're
out.
bound by
Yeah, look at
everything
this.
here, and,
So they can't make any dramatic changes to it between now and,
they can't make any changes to
can't
the
make any
documents
No.
at all.
Once it's accepted by us, that's it.
okay.
So, all right, we have motion a second, all in favor?
aye.
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 No.
No.
Okay, 3 ayes, 1 nay.
Great.
Okay, so Jonathan, where are we signing, right here?
Oh, you know what?
Can I have one question?
Yeah, just hold on, Steve, I just want,
Okay.
Perhaps what would make sense is for the board to, since, and I apologize for that, should have put in
Should put in the
fi-
town.
5 lines.
Mhm.
Well, town is already defined as the town of
Right.
Charlton, so it's just that I didn't know who would be signing, given timing and everything. If the board wants to take a vote to authorize the chair to sign the escrow agreement.
Mr. Chair,
Mr.
whether we
Savarese,
authorize the chairman to sign the escrow agreement?
is there a second?
Second,
Any discussion? Hearing none, seeing none, all in favor?
Aye.
aye.
Okay, nay. Right here.
Yep.
Yes, Steve?
Did you guys just sign an agreement without the name of the corporation you're signing the agreement with?
I would
No.
defer.
Is that what I understood here?
No. So the development agreement that the board previously signed is with Valley Green Grow, Inc. That's who the development agreement is with. The developer will be formulating, if it hasn't already, different entities that will be holding the real estate, applying for licenses. It's, pretty standard for a big development. So the development agreement has various form agreements that are attached. This is what the letter of non-opposition is gonna look like, which is a standard form letter. The entity is gonna depend on what the actual entity is that's applying for the license. There's gonna be one entity applying to DPH, one entity applying to the Cannabis Control Commission. One has to be a nonprofit, one doesn't. So it's standard to say, look, here are the forms of the agreements we're going to be entering into, because we want to have certainty. Whether they call their LLC Valley Green Grow Charlton LLC or Valley Green Grow Central Massachusetts LLC doesn't make any substantive difference. They just need to figure out that one particular detail. It's going to be the same principles, the same developer, and that's what the development agreement requires. It's going to be a wholly owned subsidiary, which is very standard when it comes to these types of development agreements.
But then it would be, excuse me, then it would be newly registered with the Commonwealth. Could be a different board of trustees on that group, could be a different group. You guys just signed something that you have no idea. You could be, it could be.
There are non-transferability provisions in the development agreement, and this is absolutely standard. There's no exposure to the town. We don't know who, the town isn't particularly concerned with who is on a board of directors. It's concerned with who the principals are.
Why wouldn't they be? I would want to know.
Because the business terms of the deal are the business terms of the deal, and the CCC is doing the background checks, not the board. I mean, that's the way it works. And the board isn't going and doing background, criminal background investigations on every member of the board of directors of every developer that does business in the town. So.
A little bit, I would call that due diligence, but I would at least want to see a name before I sign the document personally. But that's fine. If you guys,
It's
But
not.
for what-
it may be semantics, it may not be, but that's a red
I
flag.
think it is, and
It's a red flag.
I
to
have
me.
fair amount of experience in this field. It's really standard that the name of an entity doesn't matter. It matters that you have terms that the board, as a majority of the board, is comfortable with.
But you also said that it doesn't matter, it shouldn't matter to the board who the corporates are, or who's on that? Why would the board care about
It's, Mr.
who the
Chair,
officers are on the,
it's owned by the same people, there's the same principals, so it's the same company, basically.
It's, Steve, it's just like if Price Chopper puts up a supermarket, okay? Price Chopper has a holding company for their real estate. They also have the people that, they probably have a holding company for the equipment that's inside of the store. Then they probably have a holding company if they have a liquor license. So, but that's basically the same thing. So, because none of us here are of a legal mind, that's why we have counsel, and that's why we follow what counsel tells us to do. So, just, you know.
Yeah,
Okay.
yeah. I guess as long as you guys are comfortable with the fact that officers of the corporation can change. Because in something like this, there's part of me that thinks there probably should be some background checks on these people.
There will be.
Which there will be. That's done by the state. When
Cannabis Commission
the
does it.
Cannabis Control Commission takes care of that. That's why in here it says follow all the state laws. So,
Right.
and thanks for your comments. We appreciate it. So, with that, we're complete with this.
I think we are, we're good on all these documents. I'm happy to answer any other process questions, or.
What are the next steps?
So the next steps will be, as I said, for these exhibit documents, just for the entity names to be filled in.
Yep.
Then those documents will get executed.
Mhm.
The applicant will find a time to have the money paid into escrow within the 30 days. And then the applicant will be free to start going to the Cannabis Control Commission, DPH, filing with the planning board for site plan approval, and proceeding with the permitting process.
Okay. And we'll be apprised of all these different steps as they go through.
For sure.
Okay, very
Yeah.
good.
So,
Excellent.
Thank you very
John.
much.
Appreciate it.
Can I ask one more question?
Sure.
You're probably going to hear this actually August 1st, so if you haven't heard it already. So obviously, we have a special town meeting on August 1st, and I believe we have two questions on the warrant.
2 warrants.
Two warrants.
Two articles on the
Two
warrant.
Thank you, Joe. Can either of those articles impact this particular project?
So the article to rescind the zoning amendment that was passed,
That was
At the
Article
last-
Article
27.
27.
right, the last town meeting. Though it doesn't say so, the town is treating it, in the interest of being trying to affect the intent of the petitioners, is treating it as an article to rescind the bylaw itself, to amend the zoning bylaw to basically delete it. So if that bylaw is deleted, if the bylaw is not deleted, has no impact on this project. Because this project is on property that is the subject of a preliminary subdivision plan that was filed before the town meeting, which freezes the zoning in place. So the passage of Article 27 had no impact on this project. The deletion of Article 27 would have no impact on this project. It would simply revert the town to its prior zoning, which had no specific regulation of marijuana establishments. So that would be the impact of that article. There's another article that would adopt a general bylaw to prohibit all marijuana-related uses. That article, if it passes at town meeting, would have no effect until and unless at a townwide election, there was a ballot question that passed that basically ratified that bylaw. If that general bylaw passes both at town meeting and at the townwide election, then the question becomes, would that impact this project? And I'll be frank with you, there's no case law. As a general rule, there is case law that says towns may not regulate through a general bylaw something that is typically regulated through zoning. For instance, there was a case where a town tried to regulate off-street parking uses through a general bylaw rather than through a zoning bylaw, and the court struck that down and said, no, you can't, if it walks like a duck, quacks like a duck, it's a duck. This is something that towns typically use their zoning power to regulate. It's a use of land. So the court said, no, that's not valid. Here, what we have is sort of this strange provision in the statute that says a town can pass a bylaw. It doesn't specify zoning general, the statute just doesn't really give that guidance. The Attorney General has approved some general bylaw prohibition provisions, but with a strong caution saying, we really think you should do this by zoning. We're not striking it, we're not rejecting it, because that's not really our purview, but essentially there's some exposure as to whether or not this is valid, and we recommend you go back and do it as zoning bylaw. But to my knowledge, there hasn't been any litigation that has tested that issue. So I'm sorry for giving you such a long-winded explanation, but I want to, give you as much information as possible. Mm-hmm. If the general bylaw passes both a town meeting and a townwide election, there is an argument that since there's no freeze of general bylaw provisions, and I assume this is why the petitioners drafted it as a general bylaw, since the preliminary subdivision plan doesn't freeze general bylaws, it only freezes zoning bylaws, there's an argument that could be made, and I'm sure it would be made, that it would therefore prohibit this project, even though they had the preliminary subdivision plan in. Now, obviously, we're in an open session, I want to be really careful. Mm-hmm. The developer might have some legal arguments to make in that regard and possibly seek some damages. And that would be a whole other, can of worms that I don't think we need to open up now. But that is the Reader's Digest of what's really a very complicated issue.
I appreciate that, thank you.
That was an excellent explanation of that.
Yes.
Thank you for that. So, when the Attorney General extended the deadline from...
We're getting away from what we have posted right now.
Yeah, I know.
I do appreciate the question, Karen, but yeah, we're getting away from what we had posted. Right. And I appreciate it. And I'm sure if you want to ask Jonathan a question outside, I'm sure he would answer.
Yep.
So.
Only with the caveat that I do have to be careful because I'm representing the town and
but
the nation.
In generalities, I'm sure he wouldn't mind talking to you for a minute. But with that, I'm going to move on. Is there any other business unknown at the time of posting? No? Okay.
Mr. Chair?
Mr. Safarovich.
I move that we enter executive session under Mass General Law, Chapter 30A, Section 21, for reason number 1, to conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel, a personnel contract, if the chair declares that an open meeting may have a detrimental effect on the negotiation position of the public body, and to return to open session solely for the purpose of adjourning.
And the chair so declares, and will enter executive session by roll call vote. Ms. Spiewak.
Aye.
Mr. Safarovich.
Aye.
Ms. Noble.
Aye.
Chair says aye. We're entering executive session, and we will exit only for the purpose of adjournment. Thank you.